Welcome, everyone. In this session, we will explore foundational concepts in constitutional law. By the end of this presentation, you should be able to define what a constitution is, identify the relationship between the state and the individual as framed by the Constitution, and recognize the basic sources of the UK Constitution. For a deeper understanding, please refer to the following readings available in the library. Mark Elliott and Robert Thomas, Public Law, 5th edition, OUP 2024. Hilaire Barnett, Constitutional and Administrative Law, 15th edition, Routledge 2024. To comprehend constitutional law, we first need to understand the concept of a state. A common model in Western democracies is the social contract, which philosophers like Thomas Hobbes, John Locke, and Jean-Jacques Rousseau have extensively discussed. For example, Hobbes believed in a strong central authority to prevent chaos, while Locke emphasized the protection of individual rights and limited government. Now, let's address the question, what is a constitution? In most countries, this is a straightforward question, as it typically refers to the central piece of legislation governing the state. Some historical examples include the Stele of Hammurabi from Babylonia in 1772 BC, the Golden Bull from the Holy Roman Empire in 1356, the Instrument of Government from England in 1653, and the United States Constitution from the USA in 1787. There are various definitions of a constitution. S.E. Feiner states that constitutions are codes of rules which aspire to regulate the allocation of functions, powers, and duties among the various agencies and officers of government, and define the relationships between them and the public. A king describes it as a set of the most important rules that regulate the relations among the different parts of the government of a given country and the relations between the different parts of the government and the people. A constitution serves several critical functions. It regulates the functions, powers, and duties of different parts of government. It defines the relationship between the state and its citizens. It holds superiority over other laws in the state, whether implicitly or explicitly. It reflects the history, identity, and values of a society. Let's now focus on the UK Constitution. The UK does not have a single written document or defining moment in history. Rather, it has evolved gradually. Its constitution consists of statutes, conventions, judicial decisions, and treaties, making it uncodified rather than unwritten. Question for discussion: can you identify any issues that arise from this model? According to K.C. Ware, constitutions can be classified into various categories, written and unwritten. The UK has an uncodified constitution, rigid and flexible. The UK Constitution is flexible, supreme and subordinate. The UK Constitution is supreme, federal and unitary. The UK is a unitary state with devolution, separated powers and fused powers. The UK exhibits both characteristics, republican and monarchical. The UK is a constitutional monarchy. There are several central concepts in the UK Constitution: parliamentary sovereignty, rule of law, separation of powers, royal prerogative. Many acts of Parliament are fundamental to the UK's Constitution. Due to parliamentary sovereignty, all acts can theoretically be repealed by another Act of Parliament. Important examples: Magna Carta from 1215. This document set fundamental rules for governance, such as prohibiting unjust taxation and ensuring the right to a fair trial. Bill of Rights from 1689. This established rights for Parliament and laid the groundwork for future rights. Example: the bill requires parliamentary consent for tax and budgetary measures, ensuring accountability. Let's briefly review some other significant acts. Act of Settlement 1700, Acts of Union 1707, Parliament Acts 1911 and 1949, European Communities Act 1972, Devolution Acts 1998, Human Rights Act 1998, House of Lords Reform Act 1999, Constitutional Reform Act 2005. Now let's discuss the importance of case law in constitutional matters. Decisions made by higher courts create binding precedents for lower courts. Example: cases establishing common law. Prohibitions. Delroy, 1607, established that the king cannot administer justice. Dr. Bonham's case, 1610, indicated that common law can control acts of parliament. The European Communities Act 1972 had a significant impact on the UK legal system. It brought in EU law through treaties, regulations and directives influencing UK law, a trend that continues even post-Brexit. Finally, let's explore constitutional conventions. These are important sources of the UK Constitution and, while not legally binding, they guide the conduct of government officials. According to Dicey, conventions are understandings, habits, or practices that regulate the conduct of governmental members without being enforced by courts. Breaching a convention can lead to legal issues or political scandals. For example, if Parliament fails to meet and the army is paid without parliamentary consent, it violates the Bill of Rights. In conclusion, understanding these concepts is essential for grasping the complexities of the UK Constitution. These foundational elements help you comprehend the interplay between law and governance. I encourage you to think critically about these topics as they will be vital in your studies and future legal practice.